So we've heard from Professor Kate various implications of PACE, but of course there are also huge cost implications. And by the time we reached more recent times, 2005, the government had decided to set about curbing costs. The Lord Carter's review was prompted, amongst other things, by claims that there had been a 37% increase in criminal expenditure and a 24% decrease in civil and family legal aid since Labour came to office in 1997. And of course Lord Carter recommended a market forces approach based on economies of scale, including the fixed fee system. And in 2007, the Law Society and others were able successfully to judicially review the government's new civil contract here. So many firms and lawyers have spoken out against the recent changes, saying that they will undermine the future really for all of us in the room. And none has done more so than our next guest, who, an expert in many fields, is also a firm advocate of access to justice and really an inspiration to all young and aspiring lawyers. She's also the patron of our host, Young Legal Aid Lawyers Association, the first woman solicitor QC, so great honour to welcome June Venters, QC. You're not immensely impressed by some of the changes to legal aid. Could you just talk about some of the more worrying aspects of the government's proposals and changes in public funding?
Well, I think everyone knows I've spoken out now so many times about Lord Carter. It's very difficult to find something that was original to say about Lord Carter. And I thought really that the only thing now I could equate it to was the tsunami of the legal aid profession. And I thought, well, why do I think it was the tsunami? And I think that it was mainly because it was brought in my opinion, in a rush. There was clearly no sense of direction. It crushed the innocent and the vulnerable, and it's been left to many professionals to sort out by way of a rescue package ever since. And I thought that's probably where it would end for me tonight in relation to commenting on Lord Carter, until I realised only in the last 24 hours that in fact here we go again. And it seems to me that we're now on yet another roller coaster where we're going to have yet another review.
So also, as a family solicitor advocate, what do you think of the changes will have by way of impact on vulnerable children being represented?
Well, when I was here this time last year, I spoke about the government having blood on their hands, and my word, I didn't realise that that was going to come true, because it really was only a few months later that the Baby P case broke. And whilst I know we can't say that that was as a direct result of legal aid cutbacks, it was nonetheless as a direct result of the cutback in resources. And what I would say in relation to family cases, and I would say in relation to criminal cases as well, that these are areas where expertise is required. You can't have a quick fit in relation to a child or in relation to a person's liberty. What worries me is what is now on the horizon, because I see that we're now going to be having a focus on priority cases. My understanding of that is, for example, that there is now a very big question mark as to whether or not someone who is in the United Kingdom, if they're not in the United Kingdom lawfully, will now be entitled to legal aid. And I suppose if we open that up to the public generally, the public would say, well, that sounds like a jolly good idea to me. Why should we be wasting money on people that shouldn't be here in the first place? But actually, you need to look at this a lot more closely, and let me just give you an example. And I've represented many a mother in this situation, and those of you who do family, I'm sure, have done the same. Imagine a mother who is here seeking political asylum, and for one reason or another, she becomes involved in care proceedings, which may not be her fault. For example, her child may have been accidentally injured, but she's actually thought to have injured the child deliberately. So care proceedings are issued. In that situation, she is not going to be able to claim legal aid. It may well take her, as is usual, probably about a year to go through the system before she actually can be in this country lawfully. That year will have seen, given the time frame that we now have to complete care proceedings, the end of those proceedings, someone not being legally represented, someone who cannot speak English and therefore will not be able to afford an interpreter, and the child will be adopted. That is the consequence of these policies that are being considered. And I urge the government, and I urge Mr McGee, who unfortunately for him works for a company called Booz & Co. Doesn't hold out much hope for me, but there you go. I would urge him to actually look at the consequences of what they're doing and stop going for vote catching, although perhaps they burn their bridges on that anyway.
And on a slightly more personal note, how do you see the significance of your own appointment as the first woman solicitor QC?
I think anyone that knows me well knows that I see myself as a representative of my profession. I'm very proud of my profession, and anyone that works in the field of legal aid, whether it's at the bar or whether it's as a solicitor, works very hard and is very committed to what they do. And I see myself, therefore, as nothing more than a representative, and it's an opportunity to speak out for the next generation coming through, because if we don't speak out for you, who is?
Thank you very much, Jude.